All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores, Senator Orenshaw,
Here.
Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
And I am here, thank you. Please mark Senator Flores present when he arrives. Welcome everybody to Senate Judiciary. We do have a work session on our calendar this afternoon, as well as a bill hearing. So we will start with the bill hearing, and I will invite our colleague Senator Orenshaw down to the front to present SB 383, and I will officially open the hearing now.
Good afternoon, Chair Scheibel, members of the Senate Judiciary Committee. For the record, James Orenshaw. I represent State Senate District 21 down in Southern Nevada. Thank you for hearing Senate Bill 383. I really appreciate your taking the time to hear the bill. If the bill looks familiar to those of us who were here last session, it is familiar. It is the exact language that was in Senate Bill 359, first reprint, that passed this committee and passed the Senate unanimously. Unfortunately, got stalled over on the other side. And, if at first you don't succeed, try again. I believe Senate Bill 383 is a very important bill, and I want to discuss it a little bit, and then I'm happy to answer any questions. Senate Bill 383 seeks to redefine the use of community service, making it more meaningful for a child, parent, guardian, and to provide positive experiences to help ensure that a juvenile does not reoffend in the future. It also adds an alternative option to community service, allowing a child, parent, or guardian to participate in programs whose primary purpose is to build job skills and increase employability. Finally, the bill gives the juvenile court options when it considers the application of a fine, community service, or suspending or delaying the issuance of a driver's license. A brief overview of the bill. Section 1 revises the definition of community service to mean a community-based activity that facilitates civic engagement, provides training in life skills, or increases the employability of a child. As outlined in Section 1, the goal is to foster empathy for victims of crime, repair harm to both victims and to the community, and to encourage children to develop critical thinking and problem-solving skills. Section 1 also highlights the importance of helping children understand community issues, try to make positive changes in their lives and in the community, and to feel personally invested in the well-being of their community and for themselves. Section 2 provides the juvenile court with the option of ordering a child, parent, or guardian to participate in a program whose primary purpose is to build job skills and increase employability as a form of community service. Section 3 authorizes the juvenile court to order a child who's been deemed to be a habitual truant to perform between 8 and 16 hours of community service the first time a child is adjudicated to be a child in need of supervision. Or, under Section 3, the court may, in lieu of all or part of the fine, order up to 10 hours of community service for a combined total not to exceed 20 hours each time that child is adjudicated to be a child in need of supervision due to habitual truancy. Sections 4 through 7 authorize, instead of the current language in the NRS that requires the juvenile court to add an additional suspension of a driver's license or delay the issuance of a driver's license of a child who is adjudicated delinquent, who is already the subject of such an order for certain offenses. And just to explain a little bit the genesis for the bill, many children who end up on juvenile probation or adjudicated delinquent children have community service that's mandated by statute, whether it's on the graffiti statutes, possession of a firearm, and very often I see children, I talk to juvenile probation officers who work with kids they supervise, who have a lot of trouble finding places that will accept them to try to perform that community service. Either they don't have an opening, or they don't want to work with a child who might have had a firearm offense, or let's say some other different offenses that they're just not willing to have that child work with them, whether it's stocking food shelves in a food bank or other kinds of community service. So a lot of times what I'll see in juvenile court is children who may be doing very well on juvenile probation, may have done their counseling, may have been able to pay off the restitution, but they still have 120 hours of community service, because even though they've been trying every weekend when they're not in school to go perform community service, it's been a real struggle to try to find places where they can get the community service done. And I believe that this will expand some of their options and, again, give kids a realistic goal to be able to say, this is where I'm going to be able to get this done, get this behind me, close the book on this chapter of the mistakes I made, and hopefully return to being a normal teenager. But unfortunately, there's a lot of kids now who trying to get that community service becomes a goal that keeps getting pulled away from them as they try to get it done. So I believe that this bill will help children be successful on probation. It'll help them, invest in themselves and help the community by expanding some of those options. Again, the sections 4 through 7 that give discretion to the juvenile court about the driver's license, there are many juvenile offenses that didn't involve a car. The child wasn't involved in any kind of driving at all. And there, I believe that the juvenile court should have jurisdiction as to whether they want to suspend the driver's license or not. So with that, Chair Scheibel, I'm happy to answer any questions.
All right, thank you so much. Questions from members of the committee? Senator Ellison.
Ma'am, so much. I appreciate it. Hey, I do have a question. What if a child has got community service, but he has to pay off a fine? He can't afford to pay it because they don't work. So, and say that he has to do 10 hours of community service, but yet the restitution is higher than that. So do they add more time to his community service? How do you do that?
Through you, Chair Scheibel, to Senator Ellis and James Orenshaw, Senate.
Please go with direct.
Oh, thank you, Chair. James Orenshaw, Senate 21, for the record. What I've seen as a public defender representing children in juvenile court is that if the statute for the delinquent offense doesn't require community service, sometimes I'll see the juvenile hearing masters or the juvenile judges order community service. Very often what they'll order is non-statutory community service, what I've seen recently. Non-statutory means that it doesn't have to be performed pursuant to the statutes here in Senate Bill 383. It could be extra tutoring at school. It could be participating maybe in a mentoring program, like a Big Brothers Big Sisters program. Down in Southern Nevada, we've got some real good mentoring programs that help kids. And there's a little more flexibility there in terms of trying to get that community service done. Now, sometimes if there's a mandatory fine in the statute, sometimes if the child and their family are not able to pay that fine, I will see some judges allow extra community service to try to be served in lieu of that fine. Now, with restitution, that's cash that has to be paid to the victim. So the community service would be a separate order. I know in years past, down in Southern Nevada, juvenile probation had a program where children could try to perform community service and earn credits towards restitution. I don't think, since COVID, I don't think they've had that program there. And I don't know about other jurisdictions, whether they've had a program where kids, if they and their family couldn't afford the restitution, let's say to fix a car, if a child was found with a stolen car, that there could be community service performed, but that's separate from this. This is the court-ordered community service. So the restitution usually is a separate pot that has to try to get paid off, by the child and their family to the victim.
Thank you, ma'am. I appreciate that. And that's the only question that I had. It's a pretty good bill. Thank you.
Thank you, Senator Olson. Thank you, Chair.
Any other questions from members? Okay, Senator Hansen.
Thanks. Reading through the current law, I mean, you're changing some shalls to may, basically, for when after a second offense or something like that. Currently, it's mandatory that they suspend their license, or if they don't have one, to postpone it for a certain window of time. You're obviously working in this area a lot. I mean, we're talking gun crimes by children, but you can be 17 years old and you're running around with a pistol, and then this is a second offense, and current law says they shall have their licenses potentially suspended. You want to shift it to may. What's the reasoning behind that?
Thank you, Senator Hansen. I think every child is different and every set of facts is different, and there may be scenarios where there was nothing involving a vehicle in what the child was involved in. And there are scenarios where I believe the juvenile court should have discretion. That's the reason here. There's nothing that would stop the juvenile court from suspending the license or postponing that if they still wanted to. It's just that I believe that making it a may instead of a shall gives the juvenile hearing master or the juvenile judge who's closest to that case and able to get reports about the child from probation, be able to hear from the district attorney and from the defense attorney, from the child, their parents, from the victim. Really that sense as to whether this is the appropriate case where I need to make sure that driver's license is suspended or not. And, there might be special, there might be a child, who notwithstanding committing the delinquent offense has been gainfully employed or has got to, travel a long way to get to school. There might be instances where if the delinquent act is not related to driving, that the juvenile court may feel even a suspended license, like to work and back, to school and back, would be appropriate. And here I think this gives them discretion that they didn't have. If this passes, I don't think floodgates are going to open up and judges are going to suddenly no longer suspend licenses, but I think this will give them the discretion to look at cases where, let's say the child's been gainfully employed and then got caught up with the wrong crowd and, got a delinquent offense, ended up in the delinquency system on juvenile probation, but they still need to be able to travel to be able to go to work and to drive to go to work, and maybe their parents don't have the flexibility to be able to take them or aren't able to, that the judge might be able to allow that, maybe a restricted license to work and back or to school and back.
Well, that seems reasonable. I was just kind of wondering, because I'm almost wondering why we had it shall, but it's after some pretty serious second offenses, what it sounds like. Now, question on the community service part of it. You mentioned some of these kids, frankly, are, dangerous, scary, or whatever, gun crimes and so forth, and there are people in the community, they're uncomfortable having them in a community service type thing. Now, I've seen, I don't know, do they do this with juveniles where they're out in a jumpsuit, and pulling weeds along the road as part of community service? Is that something we've gotten completely away from for people under the age of 18?
James Orenshaw, Senate 21, Senator Hansen. I think that would vary by jurisdiction and by how things are working in a particular area with juvenile probation. I can't say it's been totally done away with, but I don't think that's the goal here. I think the goal here is certainly things that benefit the community and also help the child try to work towards that goal of not ending up in juvenile court again, because I think the number one goal of everyone in the system, the prosecutors, the defense attorneys, the juvenile probation officers, the state youth parole officers, if we were to get to that point where a child's on youth parole, the judges, is to try to provide services for that child so that hopefully they won't commit another delinquent offense, they won't violate probation, and they won't be back in front of the judge, other than maybe to get their case closed or earn a reduction. So I think that would vary depending on the jurisdiction, but I think that's certainly not the trend now in terms of community service for children.
Well, the reason I bring it up is if the kid's scary enough that, certain types of community service organizations would feel uncomfortable having to do their service hours. I mean, I'm worried about the public safety for people in that. Now, when there is somebody that's given community service, there is no probation officer watching them or something like that to make sure that when they are involved with a community organization that would qualify under this, that the people that are working for that are actually potentially protected from what apparently could be a fairly dangerous child of 17 years of age.
James Orenshaw, Senate 21, to Senator Hansen. Again, I have had clients, I've represented children who have been able to get some community service at a probation center working with their probation officers, and this will expand those opportunities, perhaps a mentorship program. And certainly anybody who's going to consider a child for community service, is going to, have that information as to whether they want to accept the child or not. And usually when a child's going to start working with community service, they've met with their probation officer, they've talked about the pathway to success and to staying out of trouble, and hopefully getting that chapter of their life closed, finishing the orders of the judge, doing well on probation, and closing the door and moving on to hopefully being a normal teenager again.
Okay, well, now you just added another point. Are the community organizations notified in advance what the kid has been convicted of?
Probation should let them know before they consider a child.
Okay, so in my mind, I'm just like, you're going to assign them to whatever, United Way or something, and they have no clue what this individual may have been convicted of and why he has to do community service. So, thank you, Madam Chair.
Sure. I will go to Vice Chair Flores next.
Thank you, Madam Chair, and thank you again for bringing up this legislation. Maybe I'll start off just with very general questions. Presently, when we're working with this population of minors, do you find that most of the poor decision-making is often related to just who they're around, their friends? Talk to me about the typical profile of the student you're working with, or minor, excuse me, that you're working with. Do you think it's more to do with their elements, the people they're surrounded by, or are you working with a different type of profile? Just give me an idea of who you're working with.
Thank you, Senator Flores. James Orenshaw, Senate 21. One thing I notice is that I think it's a very tough time to be a teenager these days. Certainly a lot of, when I was growing up back in the 80s, not the 1880s, sorry about that, 1980s, I feel like the 1880s, there was no Facebook, there was no Instagram, and now, kids don't get much of a break from this electronic social media. So I think that's a lot of pressure on kids. I think a lot of kids I represent have suffered a lot of trauma in their lives. There's a lot of kids who have, missing parents, sometimes two missing parents, have been in and out of the foster care. There's a lot of kids who have undiagnosed mental health issues, substance abuse issues that never gotten any treatment. And unfortunately, sometimes following friends who are, very popular, it seems to be the way to go in terms of following friends. So I think it's a tough time to be a teenager. And, I think here, in terms of the bill and the merit of the bill, I think this gives kids who, are going to be ordered to complete community service a realistic chance at trying to get it completed and to be successful with their orders from the court with probation.
Thank you. And do you see in that scenario, you're surrounded by the wrong crowd and there's all these outside pressures. Now, traditionally in the models that we're accustomed to when we talked about community service, do you see community service was more designed for punishment than it was for rehabilitation, for reincorporation, for advancement to help? Where do you see community service today versus what you think this bill would do?
Thank you. James Orenshaw, Senate 21. The model of juvenile court is a model of rehabilitation and treatment services. It's not a model like the adult criminal justice system of punishment. And certainly when we think about community service for adult offenses, for adults who've been found guilty of a criminal act, we are thinking more about punishment. We are thinking more of going up and cleaning on the roadside, things like that. Things that are not meant to be fun, not meant to be pleasant, and also not necessarily meant to enrich or teach a new trade. I think here, certainly the goal of community service has always been to try to help kids, to help them be successful and enrich them. I think with the changes proposed in Senate Bill 383, it will give those kids more options to try to, be successful, learn, job skills, be successful in school, and to have an attainable goal, to complete the community service, so that even if maybe they've completed the rest of their orders, they don't have that hanging out there. Because even if you could find a place that would let you do 5 or 6 hours a weekend, which a lot of times that's the most a lot of clients can get, trying to get 100 hours, 200 hours, it takes a lot of time. And not every weekend it's available. And this, I think, will give kids an attainable goal to try to complete successfully their community service and their probation.
And Madam Chair, if I may ask one more thing, and do you see this, in reading NRS 62E.190 as it, without the amendment, I feel that community service there has kind of a start and a finish. And what I mean by that is, you show up and you work with this nonprofit, you show up and do this graffiti cleanup, you show up and you work with this political subdivision, you do whatever it is, and then you complete your hours and you're done. But I see your bill as almost a bridge or a continuation that goes from rehabilitation, a skill set, a relationship that goes beyond the completion of hours. Do you see that? Do you see that as doing the same thing? That it becomes more than just completing hours, but now it actually gets into building a bridge of what it means to say, I've paid my debt, I've made my mistake, and I'm taking care of it. But now I'm also going to utilize this community service as an actual map or a bridge to continue moving in the right direction.
And thank you, James Orenthal, Senate 21. Senator Flores, I think it certainly could work that way. I once represented a child who had very, very serious substance abuse issues, and the juvenile court sent that child to inpatient substance abuse treatment. And near the end of his program, they wanted once he turned 18 to hire him to be a substance abuse counselor to try to counsel other youth. And I know there are other examples I've seen where youth will sometimes end up counseling kids who've gotten in trouble. So can I say for sure this will happen? I can't, but I think that it's possible that children who participate in more meaningful forms of community service, may want to keep giving back in the future once they've closed that door, finished juvenile probation, and gotten back to being a normal teenager. Then I think that this might help them want to continue that.
Thank you, Madam Chair. Thank you.
Other questions? Okay, I have a question, and I was trying to do some real quick legislative history research here, and maybe legal can weigh in, or maybe Senator Orenthal, about, in general, 62E.650, 62E.690, and I think there's one other, 62E.440. The provisions that indicate that the court shall suspend a kid's driver's license if they've been adjudicated. And my question is if there is some kind of policy reason behind this, like it's tied to federal funding or it's tied to some other standards that we have to meet, because I think that preventing kids from getting their driver's licenses and being able to transport themselves to and from community service is also a major reason I have seen clients be unable to complete community service hours. Do you have any insight?
James Orenthal, Senate 21. Thank you, Chair Scheibel, for the question. I'm not, if there's any tie to anything like that, federal funding, I'm not aware of it. My feeling here with this change is that giving judges more discretion is more of a positive thing in terms of trying to be there on the ground, seeing the child, getting the reports from probation, sometimes getting a clinical report from a clinician as to things the child's gone through, which could be traumas, because certainly in many cases it may be appropriate for the judge to suspend a license, but there are cases where it may not be. And again, I have seen cases where children have been working, consistently driving to work and back, and the delinquent offense that they ended up committing didn't have anything to do with driving, didn't have anything to do with cars, and didn't have anything to do with their job. Unfortunately, they made a very poor choice, and that might be the kind of case where the judge would want to say, maybe I'll want you to just have a restricted license to work and back and to school and back, not to go to, anything else, not to hang out with friends, just so you don't lose your job and so that you keep going to school.
Thank you. So, in fact, I would support amending the bill to change all of those shalls to mays, to allow a judge the discretion to allow a child to continue to utilize a driver's license or to get a driver's license, because I agree. I also had a client who was working at the time that he received his offense, and so he went from being at work 8 hours a day and having something to do with his time and a place to be, to having to quit his job and stay at home while his mom went to work. And let me say, it did not help him stay out of trouble to be at home without a job, because he no longer had the license, and his house wasn't on a bus route that was accessible for him, and his mom couldn't drop him off at work every morning. So I would support an amendment that changes all the mays to all the shalls to mays. But that being said, I think it's a great bill. It's a great opportunity for kids to really turn their lives around, and that's a comment, not a question. So thank you.
Well, thank you, Chair James Ornshaw, Senate 21. Thank you, Chair Scheibel, for the comments. I'm certainly open to any amendments anybody would want to propose, and I appreciate your committee hearing the bill. And I'm
Absolutely. All right. Unless I've inspired other questions, then we will close out the presentation portion of the bill, and we will move to testimony in support of SB 383. Anybody wishing to give support in person is invited down to the front to do so now. I see some people coming down in Carson City. I don't see anybody moving in Las Vegas. We'll start here in Carson City.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K, and I am the Nevada State Director of the Fines and Fees Justice Center. It's always good to be at the table with the District Attorneys Association. Fines and Fees Justice Center strongly supports expansions of opportunities for youth like we see in this bill. We've seen it work across the country. They do this in Texas, and it works fantastic. We also strongly support any discretion with driver's license suspension. I usually stick to facts, but I'll tell a brief personal story. I was a juvenile once who ended up with his driver's license suspended and some community service that I had to do. Luckily for me, the driver's license suspension was not very impactful. I, however, went to a school with a kid who lived with a single father who was on dialysis, and his son drove him to school, or to dialysis back and forth when he needed. If he had had his driver's license suspension, I'd hate to think what happened. Secondly, the community service that I had to do was clean the floors at the community center, which was annoying but did not give me any opportunity for growth, did not teach me anything. And had I had an opportunity like this, I think it would have been significantly more beneficial. So as someone who firsthand experienced it, I strongly support this, and so does the organization.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association in support of SB 383. I'd like to point out that Ms. Bridget Duffy, the Assistant District Attorney of our Juvenile Division, sends her regrets for not being able to be here today, but she strongly supports SB 383. Ms. Duffy helped Senator Ornshaw present SB 359 of the 2023 legislative session that, as Senator Ornshaw indicated, did not get past the finish line. We do understand that juveniles do have trouble finding providers for community service, and we support efforts to expand opportunities to help juveniles reconnect with their communities. We definitely support expanding opportunities for juveniles with respect to community service as opposed to reducing the number of hours in statute. So based on that, we are supportive of SB 383 and appreciate Senator Ornshaw. Thank you.
Mr. Jones, would you be willing to answer a question? How about we pose the question, and then you can decide whether or not to answer it?
Of course, Chair.
Okay, it comes from Senator Ellison.
Thank you, Madam Chair. My colleague asked a minute ago to move the shall to may. I don't know if you can answer that, or if the district attorney would be, or the juvenile attorney would be in favor of that.
Thank you, John Jones, on behalf of the Nevada District Attorneys Association. I know the portions of the changing shall to a may that are in SB 383 were also in SB 359 of last session, and Ms. Duffy did support those provisions. In terms of expansion, not knowing specifically what we're talking about, I can't comment on that at this time. I'm sorry.
To be fair, I just threw that out there today at the hearing for the first time. I did not run that by the sponsor or the district attorneys or anybody. So I appreciate that was a curveball. And it looks like Senator Ellison's inspired Senator Krasner. So we're going to do it again.
Thank
Go
you,
ahead.
Chair. Thank you, Mr. Jones. So a quick question, something that was asked previously by Senator Ellison. The restitution, so if a juvenile comes and burns your car to the ground in ashes, and there's a requirement that restitution needs to be paid to make the person whole again, do they still have to pay the restitution? Or do they get off with just 20 hours?
John Jones on behalf of the Nevada District Attorneys Association. It has been almost 15 years since I've worked in the juvenile division, but I believe, yes, they would still have to pay the restitution. There are provisions that allow the court to transition, I believe, some of that to community service, and if not, it can be also reduced to a civil confession of judgment as well.
Run while you still can. Please go ahead.
Okay, hello, Chair Scheibel and members of the Senate Judiciary Committee. My name is Carissa Pierce, Carissa Pearce, and I am here representing the Children's Advocacy Alliance as our Government Affairs Manager. CAA is an independent voice for Nevada's children with a mission to ensure that every child in Nevada thrives. And we supported this legislation in 2023, so I'm here to support it again. This bill is extremely important because it provides meaningful community engagement for youth who need more intensive support and guidance getting back on track. These youth may be feeling especially disconnected from their community, where punitive action alone does not show our youth that they are valuable members of the community, where they would feel encouraged to engage and grow and step away from the path that led them to the juvenile court. This bill presents a new standard of intention for community service that empowers youth to rewrite their wrong decisions, and it gives youth the opportunity and tools to help rebuild their community after they've done something that might have hurt it. These kids need to know that there is a way out, and we need to be the ones providing them the tools to take accountability and learn how to problem solve. Thank you for the opportunity to provide public comment and for your commitment to helping children in Nevada thrive.
Thank you, Chair Scheibel, members of the committee. My name is Harrison Epstein, Harrison Epstein. I'm a legal extern with the Clark County Public Defender's Office. Expanding access for juveniles to community service programs will mean more juveniles will successfully complete their probation. Prioritizing rehabilitation with community service programs will allow these young people to be more than their charges. They'll get a chance to reconnect with their community in positive ways and lead more productive lives. Thank you.
The Reverend Paul Larson, Lutheran Engagement Advocacy in Nevada. On behalf of Lutherans across Nevada, LEAN supports SB 383. Thank you so much.
Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. Learning productive life skills through community service as a juvenile is like an easy and it's a smart way to turn a juvenile offender into an adult who not only stays out of the adult criminal system, but this juvenile can use their skills and experience to help mentor other juveniles who are struggling. We all just heard Nick Shapak's story, and I think he is a great example of how this bill will work. We support SB 383 because it gives hope to children, and it's not just about punishment. So we fully encourage you to support this bill. Thank you.
Chair, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. Sometimes you just got to find the perfect people to follow so you can get a good ditto in. So ditto.
All right, I don't see anybody else coming forward to give in-person testimony in support of SB 383, either here in Carson City or down south in Las Vegas. So we will go to the phones, please, for testimony in support of SB 383.
Thank you, Chair. If you would like to testify in support of Senate Bill 383, please press *9 now to take your place in the queue.
Hello, dear members of the committee. My name is Yesenia Moya, Yesenia Moya. I am here today in strong support of SB 383. By expanding community service opportunities to include various programs, this bill does ensure that young people are not simply punished, but are given meaningful pathways to personal growth, stability, and reintegration. For many young people, involvement with the justice system can have long-term consequences that extend beyond their initial offense. A system that prioritizes skill building, acknowledges that young people need support, not just sanctions, and providing them with access to these programs will make a critical difference in their ability to do that. Punitive measures disproportionately harm young people from low-income families, creating unnecessary barriers to education, employment, and more. Instead of hindering their progress, we should be working to remove obstacles that prevent them from moving forward. We also must challenge harmful narratives that label youth as scary or dangerous. These kinds of statements are not only inaccurate, but actively harmful. When we frame kids this way, we justify policies that punish rather than uplift. The reality is that young people, especially those who have interacted with the justice system, are navigating environments that often fail to support them. Criminalization does not create safety, opportunity does. This bill reflects a commitment to long-term community well-being. I urge you to pass SB 383 and help to ensure that our system is one that supports youth rather than setting them up for failure. Thank you.
Good afternoon, Chair and members of the committee. This is Jeff Rogan, Jeffrogan, and on behalf of Clark County Department of Family Services, we support this bill and thank the sponsor for bringing it forward. We believe that by expanding community service to include tutoring and extracurricular activities that promote positive social interactions, connections, and positive behaviors, youth who have demonstrated negative behaviors will have more opportunities to learn, practice, and model positive changes in behavior while developing personal accountability. Thank you.
Thank you, Chair. The public line is open and working. However, there are no further callers wishing to testify in support at this time.
All right. It looks like someone has joined us in Las Vegas. Are you here to testify in support of SB 383?
Yes.
All right, please go ahead.
Well, good afternoon, Chair, esteemed members of the committee. My name is Chandler Cooks, ChandlerCooks, and I'm in strong support of SB 383. I've seen firsthand how courts treat youth mistakes as if they're life sentencing, burdening young people with crippling debt, license suspensions, and barriers to opportunity that leave them feeling trapped long after their mistake was made. I've worked with young people who weren't just punished by the system, but were pushed out by it. Kids who started with minor infractions, skipping school or making impulsive mistakes, ended up spiraling deeper into trouble because the system piled consequence after consequence onto their shoulders. A simple mistake, a bad decision made at 15 or 16 shouldn't dictate a young person's entire future. This bill reimagines how we address juvenile accountability in a fair, constructive way, designed to help youth succeed, not doom them to failure. I love that we're considering redefining community service to include job skill programs, life skill development, and mentorship that truly transforms punishment into an opportunity for growth. Imagine a young person who spends their court-ordered hours learning resume writing, workplace communication, or conflict resolution, skills that will stay with them long after their sentence is complete. And we know that habitual truancy is often just a symptom and not the problem itself. Many of these youth are facing poverty, housing instability, or family trauma, yet we've punished them by imposing fines their families can't afford. Eliminating these mandatory fines and replacing them with additional community service hours reinforces accountability while respecting economic realities. What's powerful about SB 383 is that it acknowledges a simple but essential truth. Accountability without opportunity is a trap. And when we strip away the tools young people need to succeed, their ability to earn income, and their access to positive influences, we create a cycle of frustration, disconnection, and hopelessness. An SB 383 is a smart policy. It's about saving futures. And I urge this community to pass SB 383 because when we believe in our young people and when we see their potential rather than their mistakes, we don't give them a second chance. We give them a future worth fighting for. Thank you.
Thank you so much. All right, we will now go to testimony in opposition of SB 383. Anybody wishing to give opposition testimony is invited to do so now in person. I don't see anybody coming to any of the tables in person, so we will go to the phones for opposition to SB 383.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide opposition testimony at this time.
All right, we will go to neutral testimony. Anybody wishing to testify in neutral in person is invited to do so now. Again, not seeing anybody coming to the table, so we will go to the phones for neutral testimony on SB 383.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide neutral testimony at this time.
All right, then that brings us to the conclusion of testimony on SB 383. I'll invite the sponsor back down for any closing remarks.
Chair Scheibel, members of the committee, James Orenshaw, Senate 21. Thank you again for hearing Senate Bill 383. Hearing the testimony today reminds me, years ago I was talking to a juvenile probation officer who stated that when kids she's supervising get ordered the 100 hours or the 200 hours of the NRS mandated community service, she feels a lot of the time like we're setting them up for failure because it's an unreachable goal. Their providers aren't there who will let them complete that service. This change, I believe, will help kids have a reachable goal when they're placed on probation and they have that mandatory community service that's ordered, have an attainable goal, and I think with that they're going to be more successful on probation versus, children who maybe been on probation for 6 months or 9 months, completed all the orders, stayed out of trouble. They still have 140 hours of community service left because they couldn't find the provider there. I appreciate the committee's interest in the bill, and I hope that you'll consider moving forward with it. Thank you.
Thank you so much. At this time, I will close the hearing on SB 383, and we will go to our work session. I do have two quick changes to the work session document and agenda. There are two bills on here that we will not be work sessioning today. Those are SB 87 and SB 152. Please do not make any inferences from my removing these from the work session. It does not mean I am killing these bills. We are having technical difficulties with getting amendments attached to proper documents, and people continue to provide last-minute amendments to their bills. And one of those people may be me. Those will come back for work session at another time, most likely. And with that, we will move into our work session, starting with SB 46. I will turn it over to Mr. McDonald.
Thank you, Chair. This is Jared McDonald, Research Division. The first bill on your work session is Senate Bill 46. This bill revises provisions governing gaming and was sponsored on behalf of the Nevada Gaming Control Board and heard on February 27th. The bill provides that the surrender or attempted surrender of a gaming license, registration, finding of suitability, or preliminary finding of suitability is not effective until it is accepted by the Gaming Control Board in the manner prescribed by the chair of the board. And I'll jump ahead into the amendment. We did have one amendment proposed for this bill. This was proposed by the chair, and it seeks to clarify that the jurisdiction of the board to investigate and initiate a hearing before the commission and the jurisdiction of the commission to conduct a proceeding and impose discipline may only be divested pursuant to regulations adopted by the commission. The amendment goes on to require the commission to adopt regulations regarding the divestiture of jurisdiction and surrender or attempted surrender of a license and registration. And then I did want to make one note that did not end up in the summary here. If you take a look at page 3, there is an additional amendment that will add a new section. And this section will seek to standardize the record on review requirements for appeals of discipline actions, employee resignations, and patron disputes. And this new section would align with section 7 of SB 46. Thank you, Chair.
All right. I think we do have at least one question on this bill. Senator Ellison, and I think this would be appropriate for you, Mr. Ross, if you would be so kind as to join us.
Thank you, Madam Chair. I think he might have answered it, but on page 9, look down on number 4 under section 7. And it says that, in one of the you have 30 days after service of petition review. One of my questions is that have an area of, say you have to try to get financing for a fine or whatever, or you're trying to get a hold of your board of supervisors or whatever it is. So it says there that you can be, your fees subscribed in full 30 days after service of the petition review shall continue grounds for dismissal. So does that mean is there a way to, if somebody had that dismissal letter, maybe I'm reading this wrong, but if you got 10 days to remove or you'll revoke your license, what I'm worried about is if somebody's trying to get through the process and you hit that 30 days, is that it, you're done, you're over, or do you have a way to get an extension?
Thank you for the question, Senator Ellison. Sebastian Ross for the record. I'm going to try to follow up just so I can understand the question a little bit better. Are you suggesting that if the fines aren't paid within, or excuse me, the fees to transmit the record aren't paid within a certain time, is that what you're trying to clarify?
Yes, that's correct. Because when I read through the bill, I had no problem with the bill. The only thing that I did have is to pay within 40 days service of petition review shall continue grounds for dismissal. But isn't there, if there's a reason why they have some kind of try to get financing or whatever for the fines or whatever, can they get an extension, or is that it? You hit that 30-day note and you're done? Because it says it revokes a license. Seemed like to me if there's an issue that brought up that says, look, I'm trying to get all financing done or whatever the bills might be or the complaint might be, is there any way that they can file for an extension?
Thank you, Senator Ellison. This is Sebastian Ross for the record, Senior Policy Counsel, Gaming Control Board. This doesn't have anything to do with licensing per se, but this is to prepare the record so the record can get transmitted to the district court for review. In the event that the petitioner in this case wouldn't be able to come up with those fees associated, currently how it's written, it would be subject for dismissal.
Okay, so it'd be only to prepare for the court?
Correct. This doesn't, excuse me, Sebastian Ross for the record, this has nothing to do with licensing, but this addresses the fees that it costs to prepare the record. So in this particular case, in Section 7, this would be the commission's preparal of the record. In the proposed amendment that we have, that would cover the board's obligations in regard to preparing that record for the district court.
Yeah, thank you, ma'am. Because when I read the top, it said the commission shall transmit the record to review, and it said must, and that was taken off to review courts within 30 days after service. And it goes on, and then it says that 30 days of service, and it was the license be suspended. So thank you.
All right. So any other questions on SB 46 or the amendment contained in the work session document? Not seeing any other questions, I would accept a motion to amend and do pass. All right, we have a motion from Senator Orenshaw and a second from Senator Wynn. Any discussion on the motion? Not seeing any discussion, all in favor say aye. Aye. Any opposed, nay. The motion carries unanimously to amend and do pass SB 46. Any volunteers for the floor statement? Not seeing any volunteers, I will give it to Vice Chair Flores. And we will now move to SB 66, and I will hand it back over to our illustrious committee policy analyst, Mr. McDonald.
Thank you, Chair. Senate Bill 66 revises provisions governing certain post-conviction petitions for a writ of habeas corpus. This bill was sponsored on behalf of the Attorney General and heard on March 4th. It revises where a petitioner must file a post-conviction petition for a writ of habeas corpus challenging the computation of time served to the clerk of the district court of the county in which the petitioner is incarcerated. If at the time the petition is filed, the petitioner is incarcerated in the state, to the district court for the county in which the petitioner resides. If at the time the petition is filed, the petitioner has released from the custody of the Department of Corrections and resides in the state. And 3, the first judicial court in Carson City, if at the time the petition is filed, the petitioner is incarcerated outside the state or has been released from the custody of the department and resides outside the state. And we have no amendments for this bill. Thank you, Chair.
All right, thank you, Mr. McDonald. Any questions on SB 66? Not seeing any questions, I would accept a motion to do pass. All right, we have a motion from Senator Wynn, a second from Senator Orenshaw. Any discussion on the motion? Not seeing any, all in favor say aye. Aye. Any opposed, nay. All right, this motion unanimously passes to do pass SB 66. Any volunteers for the floor statement? Not seeing any, this will go to Senator Ellison. And that takes us to SB 120.
Senate Bill 120 revises provisions related to the administration of justice. This was sponsored by Senator Scheibel and heard on May 5th. The bill requires that notwithstanding any other provision of law or court rule, a court that imposes a fine, administrative assessment fee, or other monetary penalty upon a person must allow the person to enter in a payment plan with the court to pay all or any part of the fine, administrative assessment fee, or monetary penalty. The bill also prohibits a court from ordering a defendant for whom an attorney is appointed at public expense to pay any part of the expense incurred in providing a defendant with an attorney. We do have one amendment that was proposed and discussed during the hearing by Nick Shepak. This amendment proposes to amend the bill to remove most of the provisions of Section 1 that would have placed certain requirements on a Nevada court when implementing a payment plan. Thank you, Chair.
Thank you, and I have one point of clarification here. The amendment that we see reflected in the work session document is what we would call a draft or a mock-up of an amendment. It doesn't necessarily reflect the exact language that legal will use when drafting the amendment. And so what the committee is voting on is conceptually the option to amend the bill to say that it will no longer be allowed for a court to impose a fee for someone to enter onto a payment plan or impose interest on the amount of the fine because they're on a payment plan. And it retains the second portion of the bill, which prohibits a court from imposing a fee for the utilization of a public defender or appointed counsel. And with that clarification, are there still questions? Senator Hansen.
No, I'm glad, thank you. The Section 1 had some issues for us. Question on Section 2, though. I don't know, maybe the public defenders know, or Brad would know, or Mr. Wilkinson, excuse me. Right now, if you have a public defender, is there a policy that they can actually bill you for? Oh, I didn't realize that. I thought it was just automatic. So we're going to eliminate that ability to bill. If you need a public defender, there's going to be no cost.
That's correct.
Okay.
This would, if the bill passes as amended, if you need a public defender, there is no cost.
Okay, and the amendment pretty much just keeps in place that you can't charge interest or any fees on any penalties. All right, very good. Thanks, Madam Chair.
Absolutely. Any other questions on SB 120 as with the proposed amendment? Not seeing any questions, I would accept a motion to amend and do pass. All right, we have a motion from Vice Chair Flores. We have a second from Senator Wynn. All in favor, aye. Aye. Any opposed, nay. The motion passes unanimously to amend and do pass SB 120, and I will take this floor statement. That takes us to SB 201.
Senate Bill 201 prohibits certain restrictions on the display of religious items in common interest communities. This was sponsored by Senator Pazina and others and heard on March 6th. The bill restricts with certain exceptions a homeowners association or unit's owner who rents or leases his or her unit from prohibiting a unit's owner occupant of a unit from engaging in the display of religious items on the door or door frame of a unit. And we did have one amendment proposed for this bill from Elliot Mallon, and he proposes to amend the bill to make the following changes. First, to clarify that notices requiring a unit's owner or occupant of a unit to temporarily remove a display must be in writing. Expand the application of the bill to include apartments. Delete subsection 2 of section 2, the provision requiring an association to review and amend bylaws and instead allow them to automatically conform to state law. And then 4, add a provision to subsection 3 of section 1 to allow temporary removal and replacement of a religious item by an association for maintenance purposes. Excuse me. Thank you, Chair.
Thank you. Questions on SB 201? Senator Hansen?
Thanks, Madam Chair. My concern actually is, since maybe the amendment removes this, I don't think so though. Section 125 promotes discriminate. You can remove a religious sign if it is judged to promote discrimination or discriminatory beliefs, but I haven't found, okay, who gets to make that call? I mean, if I put up a sign that's a Christian cross and I say Jesus loves Trump or something like that, could that theoretically be considered something that would offend somebody and be discriminatory? I know MAGA hats got kind of, people wearing them would actually be attacked in some cases. So I'm just wondering if there's some, who gets to make the call as to what is discriminatory or promotes discriminatory beliefs?
I'm going to ask legal if you have an answer.
Thank you, Chair. Ultimately, that decision would be made by the executive board as to whether a sign is discriminatory or promotes discriminatory beliefs. And presumably, if there were some kind of complaint made later or action that went before the commission on common interest communities and condominium hotels, then that would be up to them to decide as well. But initially, it would be the executive board of an association that would make that determination.
Okay, well, thank you for the answer. No, that makes me very uncomfortable. I mean, look, there's First Amendment issues involved in that. If we're going to allow a religious thing and then allow a board to determine what is an acceptable form of religious thing, display, then that really pushes it. I love everything else about the bill, but I'm going to vote no just on that line. That has to come out, in my opinion. I don't think that any board should be able to determine what is and is not discriminatory or promotes discriminatory beliefs. We're literally talking now about what somebody believes. Doesn't even say it has to. The sign itself has to show something that would be discriminatory. You could say, well, I think that thing is discriminatory. I disagree with that religious view. Islamic views maybe in this world especially, maybe something that they find discriminatory because other members may disagree with what's going on in the Middle East or whatever. So anyway, other than that, I love the bill, but that particular line, I'm sorry, I'm gonna have to vote no just on the principle that I don't think anybody should be allowed to determine somebody else's beliefs as being discriminatory. Thanks, Madam Chair.
All right, I would encourage you, did you have something? Oh, please, go ahead, Senator Nguyen.
I guess this is also a question. I'm supportive of this bill. I'm just curious, if this bill wasn't to move forward, even as written, these HOAs, can they do this already right now? They can already do this, isn't that correct?
That is correct, yes.
Thank you.
All right, any further questions? I'm not seeing any questions, so I would accept a motion to amend and do pass. All right, we have a motion from Senator Nguyen. We have a second from Vice Chair Flores. We have some discussion on the motion. Senator Hansen.
Thanks, Madam Chair. I do want to make it clear, I support 100% the idea of allowing these sorts of things. That aspect of it, from what Senator Nguyen pointed out, I agree with what she's saying, but I still think if we're going to pass a law along these lines, we should not give them an excuse to potentially deny somebody this opportunity by using the excuse of a discriminatory belief and allow that board to then essentially deny somebody what they may perceive as a religious symbol or whatever that they want to put on their own personal property. So totally support the bill. Just want to get that in because I do think that's something that maybe it can be amended out down the road. Thanks, Madam Chair.
Absolutely. Any other discussion on the motion? All right, then all in favor say aye. Aye. Any opposed, nay? All right, the sole nay is from Senator Hansen. The motion to amend and do pass does carry, and I will assign this floor statement to Senator Pazina. And that brings us to the conclusion of our work session for today, and to the last item on our agenda, which is public comment. Anybody wishing to make public comment in person here in Carson City or down in Las Vegas is invited up to the front tables now. Looks like we have some people, some people joining us in Las Vegas. Please go ahead whenever you are ready, and just make sure to give your name and its spelling when you first begin, and limit your comments to about 2 minutes.
Is it not? Okay, good. My name is Heather Shalosky, SCHERLOSKI. I own a condo and live at the Boca Raton Condominium Community Association in Las Vegas. HOAs are communities governed by a contract known as CC&Rs and the democratic principle of the right to vote. Unfortunately, there are many HOA bills being contemplated for this session that usurp the democratic process fundamental to HOAs. I presented on March 5th that our HOA can't afford electric charging stations because we had over $11.5 million stolen. The regulator, the Nevada Real Estate Division, and the Commission failed to protect HOA members from unscrupulous developers and majority owners. My husband and I became aware that millions of dollars were being misappropriated from our HOA. We went to NRED and naively trusted that they would ensure that the monies were paid back. NRED had many months to accomplish this, and they had the necessary statute to allow them to do this, including the ability to conduct an audit and get an injunction. Trusting NRED and the Commission was a huge mistake when the theft of the millions was solidified, which occurred when the developer and majority owner sold to a new majority owner. NRED still did not ensure the monies were recovered and did not ensure that all those responsible were held accountable, despite the necessary statutes and laws to do so being in place. NRED and the Commission ignored the expert forensic audit done by our HOA detailing that over $11.5 million was misappropriated, as well as ignored their own auditor's findings. Based on my experiences, this government should be focusing on how to ensure that existing HOA laws and statutes are abided by and enforced, and the tightening up of loopholes that exist. This needs to be done in order to protect consumers, specifically ordinary members of HOAs like myself. Instead, this government is focusing on micromanaging HOAs, including the installation of electric charging stations and mandating childcare businesses in HOAs. This government should be determining why state agencies such as NRED and the Commission allowed over $11.5 million to be stolen from my HOA. The reason being, so this never happens to another HOA and its members again. Clearly, after the construction defect HOA scandal, no one has taken seriously what happens when corrupt players destroy HOAs. The major players of the HOA industry, including attorneys, accountants, community management companies and managers, board members, developers, majority investors, the regulator, circled the wagons and continue to align themselves against ordinary HOA members in order to protect their status quo of corruption. Thank you very much.
My name is Ben Wiebers, BENNWIEBERS. I own a condo and have lived at Boca Raton Condominium Community Association in Las Vegas for 13 years. First, I would like to thank our legislators for allowing ordinary HOA members such as myself and others here today to be frank with you about what is actually happening in the Nevada HOA industry and how proposed legislation will negatively affect us ordinary HOA members. There is an array of special interests that could negatively impact HOAs, as evidenced by the many special interest issues that are presenting themselves in this session. Why does the state believe that following is a good idea? Allowing the circumventing of existing HOA laws and governing documents, ones that HOA members such as myself understood were in place, including contract terms that I entered into when I purchased my home, my condo unit. What I believe from being a member of a Nevada HOA is that it is important that the important contributions and real estate investments like those my wife and I make in our HOA community and contributions outside our community seem to be of little importance to state government. This does not bode well for a state that wants to continue to grow its population through migration and home ownership and investment from ordinary, hardworking people, and claims to care about the quality of life of its voting public and others who choose to buy vacation homes in Nevada. I believe with many of the bills contemplated for this session, they are unnecessary government intrusion into the operation of homeowners associations. Thank you.
Thank you both for joining us this afternoon for public comment. We do appreciate having you here and your contributions to our committee. I don't see anybody else present to give public comment in person, so we'll go to the phones, please, for public comment.
If you would like to provide public comment, please press *9 now to take your place in the queue.
Hello?
We can hear you. Go ahead.
Okay, thank you. Good afternoon, Madam Chair Scheibel and the Senate Committee. My name is Courtney Crosby. My dad is Craig Crosby, and he died at the High Desert State Prison 5 days ago on March 15th, 2025. When one of the wardens called and notified me that my dad has passed away, he called him the offender. In news articles that have reported on his passing, he has been called inmate. He was also the third person who died in custody last week, and all three men were referred to the same way, with no dignity or respect. I'm a public defender in New York, where that terminology, inmate or offender, is no longer accepted, and it has been replaced with incarcerated individual. The bill I'm referencing is New York is Bill A as in Apple 9273, and this became law in New York in 2021. I urge Nevada to follow in the footsteps of New York and implement similar legislation immediately. I would suggest that the language Nevada considers to adopt would be person in custody. And while this change may impact the language of existing statutes, I would suggest that the new change would simply state that the new language supersedes all prior existing language. New York was able to make this happen, and I don't see why Nevada couldn't do the same. And it's my understanding that this judicial term may no longer be accepting proposed bills. I urge that an exception is made. Alternatively, I would urge that this be added to a bill related to corrections that is currently pending before the committee. I plan on advocating this until it's done. I would be grateful if any Senate member would be interested in sponsoring legislation to this effect or discussing it with me further. I can share my contact information here, or I can follow up directly if a particular senator would ask me to do that. Thank you.
If you're just now joining us and you would like to provide public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no further callers wishing to provide public comment at this time.
All right, that brings us to the conclusion of public comment and to the conclusion of our meeting today. We do not have a meeting tomorrow, but we will resume again next week. And so with that, we are adjourned.